Well, I want to welcome you to a very joyous celebration of two families, really, who have made a huge impact here at the law school. I want to welcome you as Dean of this law school. I'm Stephanie Lindquist. Most of you know me. I'm the Nickerson Dean and Professor of Law here at WashU. And we are glad that everyone could join us, both here and online, for the celebration in teaching and scholarship of Professor Dan Epps and his installation as the Howard and Caroline Kaine Distinguished Professor of Law. I'd like to welcome Provost Mark West, the Honorable Josh Deal. Thank you for being here. Chancellor Mark Wrighton is also with us. There he is. Thank you so much, Chancellor, for being here. I'd like to welcome all law faculty, staff, friends, and colleagues from across the university and all visitors to WashU. And a very special welcome to Professor Epps and Professor Donro's family that are here in the first and second rows, including 3 of their 4 children. It's very exciting to meet them for the first time. We are really glad that you could join us. Finally, a sincere and heartfelt welcome, truly sincere and heartfelt welcome to Howard and Caroline Kaine and their family, all seated here in the front of the auditorium here of the courtroom. You will hear more about the Kaines shortly, but their support of Washington University and WashU Law has been transformative and is reflected again today with their support of this professorship and of Dan's work. We are so glad that you are here and so grateful to you in so many ways for your support to this university, truly. Today is a special day to honor the work and accomplishments of Professor Epps, but also to recognize the importance of these gifts that help make the law school the best that it can be and carry out its mission to the fullest. Celebrating and supporting academic excellence is critical to providing the best in legal education and research, and the Kaine family certainly represents the best of the supporting families at this university that we have. And so again, I want to welcome all of you here. We are going to first hear from Provost Mark West. So I'm going to turn the podium over to him to introduce the Kaine family and also say a few words about Professor Epps.
Thank you, Dean Lindquist. It's an honor, especially to be here. I've done many installations and enjoyed them all, but law school is my home, so I'm especially thrilled to be here. Thank you, Dean Lindquist. Today, we're here to celebrate not only Dan Epps' remarkable career, but also the incredible legacy of Howard and Caroline Kaine. Deeply committed partners in WashU's mission and longtime advocates of the School of Law, Howard and Caroline established the Howard and Caroline Kaine Distinguished Professorship in Law in recognition of the vital role exceptional faculty played in Howard's legal education. For those of you who don't know, Howard is a retired partner of Arnold & Porter, which I think has a longer name now. It's still Arnold & Porter to both of us, I assume. And he's played a prominent role in much of the most significant federal banking litigation of the past 4 decades, serving as trial counsel in a number of cases resulting in hundreds of millions of dollars in total judgments against the United States. Before joining Arnold & Porter in 1984, Howard served as the senior attorney in the Enforcement and Compliance Division of the Comptroller of the Currency. Caroline is an alumna of the University of Florida and George Washington University's Graduate School, and she has been a fierce advocate for WashU and an active community volunteer serving on the Parent Council. She deeply values the exceptional education WashU provides and continues to champion the university's mission and values. And we're really pleased to have them and their family here with us today. In addition to their professorship support, the Kaines have established and contributed to numerous funds honoring law faculty and other members of the WashU community. Beyond their financial support, Howard and Caroline have been influential volunteers within the WashU community. Howard was elected to the WashU Board of Trustees in 2010 and served as chair of the law school's National Council. The School of Law has recognized Howard with both the Distinguished Alumni Award in 2017 and the Dean's Medal in 2024. Howard and Caroline, thank you for your longstanding support of WashU and championing of WashU Law. Thank you. It's now my pleasure to welcome Howard and Caroline's daughter, Allison, forward on behalf of her parents. So the shadow box reads, "In grateful appreciation presented to Howard and Caroline Kaine, February 26th, 2026, WashU Law." Right there. How would you like?
Let's see this way. You got this light on.
Oh, this is how you want it. All right.
There we go.
We don't rehearse this, believe it or not.
Right, there it is. Other one. 1, 2, 3. Excellent.
Thank you. Congratulations. And now I believe Elizabeth Rosen is going to join us. Thank you, Elizabeth.
Tell me, can you hear me? Okay. Good afternoon. Thank you to Provost West, Dean Lindquist, and all of our esteemed guests for being here this evening. Let me begin by congratulating Professor Daniel Epps and his wife, Professor Danielle Donfro. Speaking on behalf of my parents, we are honored to have such an esteemed educator accept the Howard and Caroline Kaine Distinguished Professorship. My parents' deep affinity for WashU Law stems in large part from the incredible support my father received during his time here as a student. To quote an excerpt from the article WashU published in 2013, when my parents initially established and endowed this professorship, during my father's first semester at WashU Law, he came dangerously close to dropping out due to extenuating financial circumstances. At the end of his first semester, his dad, a department store manager, lost his job. My dad went to Dean Shelton's office and said, "I'm going to have to withdraw." Dean Shelton said, "No, we'll find a way." A couple of days later, Dean Shelton put together a package of scholarships and loans that allowed my dad to stay in school. My dad later found out that Dean Shelton literally called people and asked for donations to scrape together funds from the school to help him. My father has always remembered the extraordinary generosity and support demonstrated by Dean Shelton, Professor Greenfield, and countless others. Generosity and support that allowed him to fulfill his dream of becoming a lawyer. While many of you know about my father's professional life as a dedicated and passionate attorney and longtime chair of the Law School National Council, my siblings, Allison, Brian, and I, also know him as Dad, Grandpa H, Peepaw, the list goes on. He's a loving father and grandfather who cares deeply for integrity, honesty, kindness, and doing all he can to leave the world a better place than he found it. All values fostered by WashU Law, the place where my dad said, quote, "I learned to think." My father carried these important qualities throughout his life, mentoring students and individuals beginning their careers. In his law practice, he always included young lawyers and paralegals on complex cases. He flew to Boston weekly, serving as an adjunct professor at Boston University for 5 years, teaching a graduate banking law course, all while finding time to drive us to oboe lessons, sports practices, after-school clubs, and again, the list goes on. Thank you, Professor Epps. You have honored our entire family by accepting this distinguished professorship and carrying on the now more than ever important legal education of our future lawyers, one rooted in honesty, integrity, inclusion, and upholding the very principles at the heart of WashU Law. I find it fitting to end with a final quote from the aforementioned article. My parents, quote, "believe that the key to the future of legal education and a great law school are great teachers." Thank you, Professor Epps, for being one of those great teachers.
Good afternoon, everyone. It is my great honor and privilege to be here to celebrate my dear friend, former co-clerk, and one of the most influential legal scholars of his generation, Daniel Epps. My first introduction to Dan came through a legal blog. Dan and I had both just been hired by Justice Kennedy for clerkships, And there was this blog that would run profiles on all of the incoming clerks. So naturally, I wanted to go see who my fellow co-clerks would be. And with Dan, it included a profile picture. He was, a 25-year-old kid wearing a blazer, sitting with his hands folded in front of him, in front of a giant bookshelf filled with legal treatises and casebooks. So my first impression of Dan was, nerd. But I also thought, well, this guy looks like he's going to be an academic. And I was at least half right. From the moment we started our clerkship together, I figured out that Dan indeed was destined for academia. So many of our fellow co-clerks were insufferably certain about all these idiosyncratic doctrines, like whether or not Humphrey's executor should be overruled, and what's the proper scope of Chevron deference, but not Dan. Dan could engage in any of those debates with the best of them, but he was truly allergic to easy answers. He was willing to confront complicated questions, and he was willing to revisit even his most firmly held beliefs. And I later realized that Dan was maybe not such a big nerd when I met this law student who he just started dating, Danielle Donfro, who was now his wife, Professor Donfro. I figured if this brilliant and charismatic and hilarious woman thought Dan was okay, he must be. So my wife and I became fast friends with Dan and Danielle. I believe I have a picture of a characteristic date night we would go on during that year clerking together. I know it's washed out, but if you can't tell, Dan and I have both fallen asleep while out at a restaurant with our now wives, who somehow stuck with us so many years later. And we are all still friends to this day. We can talk about whatever issues we're going through in our personal, professional, or parenting lives. And when the pandemic hit and basically all you could do for travel was go on a road trip, we decided to meet about halfway between where I live in Washington, D.C. and where Dan lives here in St. Louis. And we drove out to Bourbon County, Kentucky, and rented a house for a week. And let me tell you, if you are going to go to Bourbon County, Kentucky, you should bring Dan Epps with you. He takes his mixology almost as seriously as his scholarship. He can make a mean cocktail. And in his day job as a scholar, Dan is shaping a generation of his fellow academics, a generation of law students, and even a generation of judges. He has proven over the decades that he still has that same unflinching commitment to examining even our most firmly held beliefs. For instance, the first article that I ever read of Dan's was called "The Consequences of Error in Criminal Justice," or as it might have been more punchier named, "Maybe More Innocent People Should Go to Prison," actually. It was a gutsy article to write, but it was challenging one of the most sacrosanct principles we have in our legal system, the proof beyond a reasonable doubt standard in criminal cases. Harvard Law Review picked it up because Dan made a clinical case for at least considering whether a system committed to that principle, one that purports to never convict the innocent, in fact, translates into more ruthless sentences. I'm not sure it sold me, but he made a strong and thoughtful case, as he always does. Dan is also a refreshing and distinctive voice on the Supreme Court, both in his scholarship, which we'll hear some of today, and through his podcast, Divided Argument. On topics where it is increasingly tempting and easy to slip into political vitriol or partisan playbooks, Dan stands as a distinctive voice of reason, committed to confronting hard questions without appealing to tribalism. He might draw a few more listeners if he just shouted a little bit more, but that's just not who he is. And finally, Dan is also responsible for my favorite moment in the history of legal Twitter. In 2018, he kicked off what became known as #Gorsuch Style, a game of rewriting famous Supreme Court lines in Justice Gorsuch's characteristically over-explanatory prose. To briefly explain what Gorsuch style is, Justice Gorsuch cannot just let a punchy line land on its own. He needs to exhaustively explain what it means to his reader. So Dan kicked off the trend, and he took Justice Scalia's classic line, "But this wolf comes as a wolf," and Gorsuch styled it into, "This wolf comes as a wolf." That is, the wolf, being dangerous, is coming to us in a way that we can tell it is a wolf, i.e., something that is dangerous, and not something that is not dangerous. And because his dad, Professor Garrett Epps, is here, I will say it is not just academia that runs in the family, it is also good humor. Garrett took Justice Holmes' famous line, that detached reflection cannot be demanded in the presence of an uplifted knife, and he Gorsaged it by adding, when another person raises a knife in your presence, you see, it is pretty much necessary to assume that this person is going to use it against you by sticking it in you, which would hurt a lot. That moment captures something essential about Dan. Yes, he is serious. Yes, he is prolific. Yes, he is one of the most influential thinkers of his generation, but he also approaches his work with a great deal of humanity, a little bit of mischief, and a lot of humor. Dan, I am so proud of you. I am grateful for your friendship, and I cannot wait to see what you do in your position going forward. I have no doubt you will not use this as a perch to rest in, but as a platform to continue doing the work that you've always been doing to make law a little bit more fair, a little bit more humane, and a little bit more rational. Congratulations.
So I was realizing that I've been in legal academia for 28 years, and I've known Dan Epps' name for most of them. And it is a real honor to be able to bestow this honor upon him. So if you're younger than about 10 years old, I encourage you to pay attention because this is the biggest medal you're going to see go around somebody's neck for a while. But for those of you who are older than 10 years old, I will read it for you. At the top, it says, Howard and Caroline Kaine, Distinguished Professor of Law, Washington University in St. Louis, 1853, School of Law. On the rear, it says Daniel Epps, February 26th, 2026. And now we will do the dance that is known as hanging the medallion. And you want to go from the back? Sure. Make sure I got you straight there. Let's all congratulate Professor Epps.
So we've been watching a lot of Olympics the last couple of weeks in my house. I'm really strongly resisting the urge to bite this medal. Dean Lindquist and Provost West, thank you so much for the confidence you've placed in me and for both of your gracious words. Howard, Caroline, Elizabeth, Allison, and the whole Kaine family, I'm so grateful for your support of the law school, and Elizabeth for your kind words. Also want to thank my family, my wife and colleague, Danielle, for her love and support, my dad, who has been a tremendously helpful guide through life and my legal career. My kids are here. Can't say you guys have been great for my scholarly productivity, but you provide a lot of joy and entertainment when I'm not working. And of course, thanks to all of my colleagues and to too many mentors to name. And Judge Deal, let me come back to you. I want to go back to the Kaine family for a moment because I'm honored to hold this particular chair. That's because Howard is someone I've gotten to know and worked with during my entire time at WashU Law. Early in my time here, when Danielle and I were at a career juncture, Howard and Nancy Stout, who was then the dean of the law school and actually the first holder of this professorship, took us out to a fantastic dinner. And they both talked to us about the future of the law school and urged us to really commit to the law school in the years to come. And we found that pitch both persuasive and deeply meaningful. And Howard and I have stayed in touch over the years, and he has really been the ideal alumnus for WashU Law. You've heard about a lot of his contributions, but he went off to DC, became an immensely successful lawyer, and then nonetheless has come back and been a great asset for this school. And his and Caroline's financial support is really only a small piece of that. And I can speak only the law school piece of it, but Howard has been deeply involved in a lot of important strategic decisions here during my entire time here. So students in the audience, I hope you're listening because this is a good model for your careers. So for these reasons, I'm particularly thrilled and delighted to have Howard and Caroline's name attached to my title as I go on in my career. Also very grateful for this chair for a selfish reason. Law is very status obsessed and a frankly materialist profession. And so when I've told my friends in the wider legal world that I had been awarded this chair. After some perfunctory congratulations, the next question was always, so is this just a title or does it come with some perks? So I'm pleased to say this chair has already come with very significant perk. One, got me back my Wikipedia page. Not joking. For many years, I had a Wikipedia page. About a year ago, I discovered that after a spirited debate, the Wikipedia administrators had deleted it because I was not notable enough. Now, one real hazard of the job of being a law professor is an inflated ego. And so at mid-career, it's a healthy corrective to have to read the anonymous lords of Wikipedia with names like Logic Soup, pass judgment on your accomplishments, saying things like, the subject appears to be a routine academic, or although tenured, he's not a named chair. Now, it turns out that under the rules of Wikipedia, that having a distinguished professorship is a loophole that automatically gets you approved. So I'm happy to say today, thanks to the support of my dean and provost, and thanks to the Kaine family, I have a Wikipedia page again. So now back to Judge Deal, who, as you heard, is one of my closest friends and was my co-clerk for Justice Kennedy and is now a judge on the DC Court of Appeals. Josh asked me to speak at his investiture on the DC Court of Appeals, which was scheduled for March 20th of 2020. That event never happened. I was never sure whether it was canceled because of an unprecedented global pandemic or just because Josh was worried about what I might say. So I want to say a couple things that I might have said then that will ultimately tie into the larger themes of my talk. So, Josh, I don't want to say that all 38 of us who clerked on the Supreme Court during the October term 2009, of all 38 of us, you were the least likely to be nominated by the President of the United States and confirmed by the United States Senate as a judge. I don't want to say it's true, but I don't want to say it. No, that aside, I want to say a kind word. And I want to do that by telling a story from our clerkship. In Justice Kennedy's chambers, 2 clerks would be assigned to every merits opinion. One lead clerk who would write the bench memo, and one second chair who would read the briefs and provide additional counsel and sometimes counter argument in order to ensure that Justice Kennedy got the best advice about a case. There was one case where our co-clerk, Misha, who is a brilliant lawyer, was the lead clerk. And it was a very complicated case involving statutory interpretation with some tricky constitutional questions lurking in the background. And so Misha ran this case totally to the ground. He read all the precedents. He studied the statutory structure. He tried to channel Justice Kennedy's prior views on the underlying questions. And he came back with a very lawyerly, very well-researched answer to the legal question. Josh, as the second chair, kind of flipped through the briefs and said, Misha, that's completely wrong. And so flabbergasted, Misha asked for an explanation. And Josh explained that while Misha might have understood the specific legal niceties, he had gotten too deep in the weeds. And the result he proposed just didn't line up with common sense and isn't one the Supreme Court of the United States would be prepared to accept. Josh, of course, was right. The court agreed with him unanimously in an opinion by Justice Kennedy. And so I tell that story because it demonstrates Josh's good judgment, a key quality for a judge, but because it will relate to my larger point, though it will take a few minutes for that to pay off. So onto the substance, Ron Levin, one of my few colleagues who is a veteran of not one, but 2 chair installations, told me that the purpose of these talks is to justify one's existence as a professor. I cannot do that before it's time for the reception to start. So instead, I want to pull together some threads of my research to make a point that I think is important. Now, a lot of my work has been about the Supreme Court, and particularly I have written and thought about ways the Supreme Court might be improved or reformed. Here, however, I want to drill down on a deeper question that I think kind of underlies all of that work. Why should we have a Supreme Court, and particularly one with the power to overturn democratically enacted statutes? Now, the most conventional answer within our legal system is that we have a Supreme Court to do law, to enforce the constitutional commitments that we put in our founding charter. I don't find this answer satisfactory. That's because in the most important cases the court decides, the legal answers really are not clear. The Constitution just doesn't straightforwardly answer some of the questions that matter most. In the cases with the highest stakes, there are usually plausible legal arguments on both sides, and it is rare in such cases for the justices to decide the case unanimously. And in fact, where constitutional meaning is clearest, such as the length of a presidential term, the text itself is the controlling focal point. And for those questions, I'm not sure we really need courts and judicial review. So I want a better explanation for why we might give the Supreme Court such extraordinary power. And I think I can find one, and I think I have two answers, although they're related. Okay, the first is that we might want an institution that can settle some of the disputes that most divide us as a nation. The Supreme Court can't resolve all of our hardest political questions, but in the cases within its domain, it can sometimes put an end to squabbling and produce resolutions that, even if they don't make every member of our divided polity happy, people are willing to live with. I was deeply unhappy with the substance of the resolution of the famous case Bush versus Gore. But perhaps the Supreme Court calling that controversy to end was a better solution than the constitutional crisis that might otherwise have ensued. The second reason we might want a Supreme Court is to have an institution capable of diffusing and separating political power. So a great threat that the founders were concerned about, and one that I think we should continue to fear today, is the possibility of all political power being held in one set of hands. Societies where one person or one small cabal has total control over the entire state apparatus are not ones where any of us should want to live. There is real value in having a Supreme Court capable of checking the other branches of government in that it could prevent a dangerous consolidation of political power. Now, I see these purposes as related for the following reason, which is that the more that judicial reasoning and decision-making just resembles partisan politics, the less capable the court becomes at fulfilling either of these two functions. So first, a court that is widely perceived as partisan is not a court that will be able to produce acceptable resolutions of divisive issues that our fractured nation can live with. Now, the court's ability to produce decisions that people will respect and follow is typically called legitimacy. Our colleague from the political science department, James Gibson, has famously said that legitimacy is for losers. And by that, he means that judicial legitimacy only matters insofar as it gets people to respect decisions that they disagree with on the merits. And the court's legitimacy is very much tied to perceptions about whether it is independent and fair. As the perception has increased that the court is partisan, public confidence in the court has rapidly and significantly declined. If that trend continues, I don't think there's much hope that the Supreme Court's decisions will produce respect and perhaps even compliance from the big swaths of our citizenry who disagree with the substance of the court's rulings. The second reason that partisanship is a threat to the court's function in checking and cabining power is that a court that decides cases in a predictably partisan fashion can't be trusted to engage in that purpose and prevent a slide into authoritarianism. Start with the conventional explanation for why the Supreme Court is going to protect separation of powers. This is the Madisonian conception of the separation of powers, that if we divide different branches of government along functional lines, executive, legislative, judicial, that's going to guard against tyranny. Each branch will be motivated to check the others because each branch wants to maximize its own authority. Unfortunately, as good as that theory sounds, in recent decades, it has been pretty thoroughly discredited by, among others, one of my most important mentors, Professor Darrell Levinson. The reason is that office holders care about politics, not institutional turf for its own sake. So we see far less checking when branches are controlled by the same political party. That said, history shows that the court has at times pushed back on the political branches. Why has the court sometimes done that? Well, we can't rest on this Madisonian assumption that courts want to protect their own power just because they're courts. Instead, as a brief detour, and then I'm going to connect, consider some other strategies that countries use to diffuse power among groups with incentives to check each other. So one strategy is to divide power along class or economic lines. In Britain, power was long shared between the monarch, the aristocratic lords, and the common people. Other societies formally divide representative power along religious or ethnic lines. Lebanon's constitution formally allocates political offices among religious communities. The president must be Maronite Christian, the prime minister Sunni Muslim, and the speaker of the parliament Shia Muslim, with parliamentary seats distributed proportionally among a number of other religious groups. Now, these systems are far from perfect, but they represent real attempts to diffuse power among factions actually motivated to check each other. Our system doesn't do that. It divides power along function, not faction. So why might we still expect the court to provide some checking of the political branches? A couple of reasons. So the first reason I think is time. Justices are appointed for life. Actions that are performed by one president or Congress today are going to be analyzed by some justices who could have sat on the court for decades. And as political coalitions and partisan interests shift, party affiliation will not always predict voting patterns. Justice Frankfurter was a New Deal liberal, but he was seen as a conservative later in his career during the Warren Court because he favored judicial restraint at a time when liberal intervention into the political process was in its ascendancy. A deeper reason, I think, is professional identity. It's because Supreme Court justices are lawyers. Lawyers are a distinct professional and social class. We have distinct norms and practices. We approach questions in a fundamentally different way than politicians do. We are supposed to care about consistency, logic, principles, analogies, not mere policy outcomes and raw partisan power. And judges are supposed to reflect those norms. And judges have a fundamentally different audience than politicians. They are not speaking to their base. They're supposed to justify their decisions in ways that the larger legal community, which cuts across partisan divides, can respect. And if all goes well, that will motivate judges and justices to make decisions that don't perfectly track political inclinations. A version of this phenomenon is sometimes derided as the greenhouse effect. The idea is that conservative Republican justices were seen as drifting to the center because they wanted to curry favor with liberal commentators like Linda Greenhouse in the DC cocktail circuit. But there's a version of this effect that actually deserves praise, not derision. I think it's a good thing if justices feel obliged to persuade both sides of our divided country that they are making decisions based on principle and not partisanship, even if that effort does not always succeed. Now, the court certainly has not consistently lived up to that ideal. Perhaps the most politically and sectionally polarized period in American history was the run-up to the Civil War. And part of what sparked that conflict, precisely how and when it occurred, was the widespread perception that the Supreme Court, because of the Dred Scott decision, among others, was in the tank for slavery in the South. The Supreme Court couldn't have ultimately prevented that struggle. Our rifts were too deep. Today, though, while we live in a deeply polarized area, I don't think our rifts are quite so severe. And I'd like to hope that a court seen as independent and above the fray and fair might be able to help draw our society together and not push us apart and to protect us from the threat of authoritarianism. I am not sure the court is equipped to do that today. I don't think the court is full of partisan hacks. I think the justices still largely believe themselves that legal principles, not raw politics, guide their decisions. But the problem is that law has changed. We have undergone and are continuing to undergo a deep shift in our legal culture. We increasingly do not all occupy the same legal universe. Instead, we now have two different ideological legal spheres: liberal and conservative, Democratic and Republican, American Constitution Society, and Federalist Society. And our media environment only reinforces this as people spend more of their time consuming media that flatters their ideological preconceptions. Fox News versus NBC, Blue Sky versus X. And I'm sad to say that universities and law schools themselves may bear some blame as we see ideological conformity in some ways at many universities and then competing alternatives at others. Our politics reinforce these phenomena. Over the prior century, we had a number of justices who did not reliably vote with their expected party affiliation. Republican Justice Harry Blackmun wrote Roe versus Wade. Democratic Justice Byron White dissented. But in the decades since, as frustration grew with justices like David Souter, who quickly drifted left, despite being appointed by President George H.W. Bush, political actors have gotten better at picking justices who will more predictably vote on partisan lines. And I think the last Supreme Court justice who meaningfully and regularly voted against partisan identification was my and Josh's former boss, Justice Kennedy. And his departure created, in my colleague Lee Epstein's account, for the first time in American history, a court in which ideology perfectly matches party. If all of these trends continue, people, in my view, will see no separation between law and politics. And that will just become a self-reinforcing spiral as the next generation of judges will feel no obligation to justify their decisions to people who are not on their ideological team. And the end of that road is a world where courts can't or won't do anything to check our political system's worst excesses. And indeed, a world where courts may be motivated to assist, not stand in the way of the enterprise of consolidating rather than diffusing political power. What can be done? I unfortunately don't have great answers, but I think we need some way to restore a legal center, some shared arena of principled argument and common ground. How specifically do we do that? Well, in some of my work, I've advocated for structural reform of the court designed to try to restore that center by selecting for Supreme Court justices who were ideological moderates and not partisans. I'd like to somehow return to a legal culture where we see more judges and justices like Justice Kennedy and like my friend Josh Deal here. Judges who pair good judgment and common sense with legal acumen and whose decisions are not a predictable function of their party of appointment. I'm skeptical today that such structural reform is feasible, and I'm also skeptical that any possible reform, if enacted, could produce bipartisan support capable of restoring a lost equilibrium. The only alternative is, unfortunately, less potent and slow to produce change. As lawyers, we should keep conversations and indeed friendships open with people who disagree with us on the deepest questions. And that means resisting the ever-present urge to speak only to our co-partisans. We see the liberal justices on the court today struggle with that choice. Justice Jackson writes fiery dissents meant to show that the conservative majority is acting in bad faith, while Justice Kaine does her best to work behind the scenes across partisan lines to forge compromises and to produce less sweeping rulings that, in her view, do less damage to the fabric of the law. I have tried to take that latter path in my public engagement, in trying to find some common ground with people who share different premises than I do. I've made no great progress. I think the people with the most power to change things are the next generation of lawyers, some of whom will be the judges of the future. And that's why I'm glad that there are a number of students here. So for those students listening, hope that you try to keep those kinds of conversations going and don't retreat into your ideological bubbles. And so I'd like to give one more thanks, this one to my students for giving me the chance to try to impart these lessons through my teaching. So if you remember one thing today, I hope it's that you should become as successful as Howard and endow chairs at the law school. No, also the other thing I just said. Thank you all very much.
Thank you, Dan. Some of you in the audience may not be aware, some of you are, that I am currently team teaching a colloquiums course with Professor Epps. And I can just speak from firsthand experience now, what a joy it is to teach with him. He is obviously so much smarter than I am, and that's really wonderful. I get to learn so much from him. But in addition to that, he is so kind and thoughtful and generous to the students in the class, patient, listening to all of their perspectives in a way that is truly a lesson to me. And I'm grateful to him for that, and for also his willingness to team teach with me, which is a gift to me. And he also does all the work. He reads all the papers. And so I am very fortunate there. I want to thank Judge Deal, Provost West, Allison, Elizabeth, for your presentations this morning and participation in this. We have a reception out in the Crowder Courtyard. I want to welcome you all to that reception. I want to thank you all for being here at this joyous celebration of scholarship, of philanthropy, of support for the law school, and of our community. And so I thank you all for being here. Look forward to having a cocktail with you in the Crowder Courtyard.